Thank you very much, David, for that excellent introduction and for your kind words. Thank you also to all the attendees. Excellent attendance records for this event. We have a lot of interesting ground to cover today, but we're really glad that you could be with us, especially since, as David mentioned, we had to postpone the event and ultimately change the date. Thank you as well to the speakers and the moderators. We have a really, really solid lineup of speakers that are going to address you today, again, on some cutting edge issues. So we're very excited about that. As for me, my name is Alex Marcopoulos. I'm a counsel at Shearman Sterling in the Paris office, member of the arbitration team. And as David mentioned, I'm working together with Banifatemi, Elise Edson, Sandrina Antohi, and Masha Tarova on this wonderful project, trying to find a way to solve some of these human rights at sea issues innovatively using international arbitration. Now, I'm not going to go into the details of the arbitration project in quite the same way David did. I'm rather going to do some more context setting. I'll let you hear from the experts on the more detailed issues that you're here to listen to them on. I am going to do three things, though, in this part of the event. The first is to really outline the core problem that this project that we're working on with human rights at sea aims to solve. So that's the first part of the context setting. And as David said, we're taking as a given that human rights apply at sea to the same extent and degree as they apply on land. That we're taking as a given. And so there should be no distinction on that basis, sea versus land. Well, if that's to be assumed, then why are violations at sea so rampant? Why is the problem so much more difficult to address at sea than it is on land? Why does human rights law, international human rights law, seem to suffer from some sort of aquaphobia, lacking any teeth when it comes to issues arising at sea? These are the issues that we're focusing on when it comes to the project. Now, based on David's excellent introduction to our work, I'm also going to extend that to the more general idea. So leaving aside this specific project we're working on, a more general idea that international arbitration can make a real difference in this field, in particular by putting enforcement of the law, enforcement of international human rights law, which is failing at present, in the hands of victims. This is the victim-centered approach that David was outlining. And I'm going to end my short PowerPoint-less presentation by teeing up the main attraction, which is the reason we're all here today. That is to hear from our speakers, the real experts in the field, who are covering perhaps not all, but substantially all of the sectors that human rights at sea arbitration will implicate. So with that outline as the backdrop, I want to start by exploring the question, why does the maritime space seem to pose such an issue for international human rights protection? The way I like to start looking at this question, at least the way I explain it to colleagues and family members, is in a way that's very personal to me, actually. It's the way actually that I first became interested in international law and ended up in this practice, and in particular in the law of the sea. So the story is about a young Greek-American boy making countless trips back and forth across the Atlantic between my parents' home in New York and our family in Athens, and always wondering, while above the Atlantic Ocean, what happens down there? What rule applies down there? Who owns that space? Can people just commit crimes and go on unpunished if they're on a ship in the middle of the Atlantic Ocean? I don't mean to suggest that's the reason why I ended up going to law school, but it's something that I really thought about and would ask annoying questions to my parents about that they couldn't answer for some time. Well, I ultimately pursued a course of study at Tulane Law School, where I concentrated on international law and admiralty. And I was very happy to learn that there are rules down there. And one of the concepts that I learned about is that while the high seas, that is the international waters that make up more than half of the Earth's surface, while they're not owned in any sense by any state or subject directly to any state's jurisdiction, states can, and indeed they must, exercise some form of jurisdiction on the high seas in that space. And how do they do that? Well, they do that by exercising control and jurisdiction over ships that fly their flag on the high seas. This is the notion of exclusive flag state jurisdiction on the high seas. And it's a notion that was born from the idea that states wouldn't have to worry about their ships sailing on the high seas being interfered with by any other nation's ships. They could sail freely without interference, and the only other ships that could interfere with them are military ships of the state whose flag they're flying. So this put me at ease, answered my initial questions, what happens down there? But the next question is, this vast area of the ocean, how is it policed by flag states? I mean, we have human rights law, but do we expect flag states to go around boarding vessels and checking out how crews are being treated? And this is not just an abstract academic question. I mean, part of how flag state jurisdiction works is codified in international law. And I'll give you one example. This is probably the most dense legalistic part of my presentation. And that one example comes in Article 94 of the UN Convention on the Law of the Sea, which addresses the flag state duties. Now, Article 94 of UNCLOS states in relevant part, I'm not going to read the whole thing, that every state shall effectively exercise its jurisdiction and control in administrative, technical, and social matters over ships flying its flag. Skipping down to clause 3, every state shall take measures for ships flying its flag as are necessary to ensure safety at sea without regard inter alia to A, the construction, equipment, and seaworthiness of ships, B, and this is the most significant part as far as our topic is concerned, the manning of ships, labor conditions, the training of crews, taking into account the applicable international instruments. So there is a source of law out there that says that flag states are supposed to be ensuring that a certain standard of conditions are met and that applicable international instruments are complied with. But here's the problem. When it comes to international human rights law, it is indeed states that have responsibility for protecting human rights, but are flag states actually willing or able to take on this task? Now, it may surprise some to learn, I'm sure there are others with us in the audience who already know this, that most of the merchant ships sailing the world's oceans today are flagged in states that don't even have a navy. So there's no way of policing compliance with international instruments, compliance with customary international law, etc. I'll give you one example, which is the Marshall Islands. The Marshall Islands, at least as of the data I checked, which is from 2018, was then the second largest ship registry in the world. Since 1991, the Marshall Islands has owned and operated one official vessel, one military or official vessel, the RMIS Lomor, which is, and this is even more interesting, it's a 160-ton inshore patrol vessel that was gifted to the Marshall Islands by Australia. So one inshore patrol vessel for this massive fleet of ships flying the Marshall Islands flag. Now, the issue is not unique to the Marshall Islands. In fact, very few of the commercial ships sailing the world's oceans are registered in states that are actually capable of enforcing their laws. In fact, some are flagged even in landlocked states, Mongolia being one example. Now, the consequences of this fact for the enforcement of international law, and in particular international human rights law at sea, is absolutely mind-blowing when you look at how rampant human rights abuses really are. I don't have time, and I don't think we collectively have nearly enough time to go through all the examples of why and how the enforcement of international human rights law fails at sea. So I'd encourage those who are interested to check out Human Rights at Sea's webpage, which, again, not exhaustive because the abuses really do run rampant, but they do go through in a lot more depth and a lot more breadth the sorts of human rights issues that are arising at sea. But I do want to address one particularly topical example. And I had the chance to look at the questions we've already received before I began my speech. And I saw that somebody had already asked whether this example would count as a human rights issue. And that is some of the issues that seafarers are facing right now because of the COVID pandemic. So, and I don't mean to suggest there's just one issue or one set of issues. The COVID pandemic is having a wide array of impacts for seafarers, for virtually every population, subset of the population on Earth. But when it comes to seafarers, one particularly difficult issue they're facing, it arises from the quarantine rules and travel restrictions that have been put in place to deal with COVID. And the issue is that they're not able to get relief from their ships aboard vessels. So they finish their job on the vessel as part of the crew. That ends, and usually the contract stipulates the duration of their shift. And they need to then go ashore and get relieved by another crew. Well, because of the quarantine restrictions and travel restrictions that have been put in place, sometimes ports aren't allowing the vessel to dock to allow the offloading of the crew needing relief and the onloading of a new crew. Other times, travel restrictions just aren't allowing planes to fly to the right places, or those crew members from being relieved otherwise. So what's happened is it's left crews effectively imprisoned on these vessels without reprieve for months and months at a time, in poor conditions, sometimes without sufficient materials. And some seafarers, as I mentioned, are having to work beyond the term of their contract without any guarantee of pay, in what amounts to terrible slavery conditions. This is not being addressed. It's continuing to go on unabated. It's one of the issues that I think underscores the failure of flag states across the board to effectively deal with human rights abuses that are occurring at sea. And we're talking now about human rights abuses that are actually getting some attention. So these aren't things that are brushed under the rug entirely. These are things that are in the news. Now, this is just one indication that the maritime space more generally is, and I'll borrow a phrase here from my colleague Banifatemi, who did a presentation on this a couple of weeks back, it is essentially a black hole when it comes to international human rights law. Many of the most popular flag states with the largest number of flag vessels are either unwilling or unable to investigate human rights issues, let alone actually enforce international law in respect of those issues. Human rights abusers are quite literally getting away with murder and rape and slavery and sex trafficking. They're quite literally getting away with those crimes with full impunity. Thus arises the question, is international human rights law simply not effective on what is perhaps the most international space on Earth, the high seas? That takes me to my second main point, which I think is the real crux of why we're here today. And that is that the answer may lie not in what the law says, not in the substantive elements of international human rights law, but rather in who is empowered to enforce the law. So that's really what's driving our Human Rights at Sea arbitration project. What we're doing with this project is exploring whether we can give international human rights law the teeth that it needs to address these abuses at sea by putting enforcement in the hands of the victims themselves. Again, that's the victim-oriented approach that David was mentioning earlier. That's set out, as he also mentioned, in our white paper in detail. We give the victim not only a private right of action against his or her abusers through a neutral and cost-effective mechanism of international arbitral procedure, but we're also focusing mainly on two goals. First of all, providing victims with an effective remedy. So at the end of that procedure, there has to be an effective remedy for the victim, which they don't have at present. And there has to also be an end to the impunity enjoyed currently by those who are committing these abuses or otherwise bearing responsibility for them. And I'd put flag states in that group as well, who are either turning a blind eye or otherwise not able to perform their obligations under international law, whether it be UNCLOS Article 94 or otherwise. Now, in certain contexts, it would appear that the individuals who are the intended recipients of international legal protections or international legal rights are actually better able to enforce those rights or protections. And as an example of that, I think we can look to international investment law, investor-state arbitration. And I think there's little doubt that an individual foreign investor's ability to pursue its rights through investor-state arbitration presents a far more effective and more efficient form of redress than what preceded it, namely the need to address investment disputes at the interstate level through diplomatic channels. Because let's face it, at the business level, unless you're a Microsoft or a McDonald's or a Huawei, you're not going to get the ear of your leaders. I think the same is true in the maritime sphere. And we really are, when we're talking about the people who are most affected by human rights at sea, we're really talking about those who at present have the least agency, the least visibility. So this is another reason why we think this approach is the right one. The serious human rights issues occurring on the high seas, not only those arising from the pandemic, but others as well, they present, we think, an excellent opportunity to test the ability of international arbitration to bring justice and the rule of law to persons and to physical spaces that seem to have evaded protection. And the high seas is smack dab in the middle of that set of persons and places. Now, we started with the white paper, sketching out what we think an effective arbitration-based system of redress for human rights abuses would look like. As you heard from David just now, as he went through the introductory parts of the white paper, the core of the system would be a network of stakeholders who are active or either active or directly interested in maritime commerce. That would include, for example, flag states, coastal states, port states, businesses active in the maritime sector, shipping companies, ship owning companies, ports themselves. It would also include, however, arbitral institutions and lawyers like us. Now, we have a good representation of those groups with us today, so we're quite lucky to be able to put to this group questions as to how this system might be able to function or what particular challenges we could face, in addition, of course, to those that are already set out in the white paper. So I encourage all of those with us today in the audience to please give that thought and feel free to pose those questions to our highly qualified speakers. We have, for example, Eric DeWicki with us of the Dominica Registry, so we have flag state representation. We have Robin Willing of the NIBC Bank. This is a bank that prides itself on ESG, and it's very active in the maritime sector. We have Martin Doe of the Permanent Court of Arbitration with us, who will be able to speak to us about arbitral institutions and how they might be able to work within the framework that we're developing. Emmanuel Gaillard, who, as many of you know, sits in the pantheon of international arbitration, both as an academic and as counsel. And we have as well preeminent shipping counsel, shipping barrister James Turner QC, who will be able to address these issues from that particular viewpoint of somebody active in the shipping industry. Now, before going into any more detail, our speakers, as I said, will address the details. A key issue that this system will face that I want to underscore from the outset, and one that we want to tackle immediately, is consent. Consent is the alpha and omega of arbitration. Consent is the way that this private system of justice gets off the ground and works. How can we ensure consent? How can we ensure that those who will be answerable for human rights claims in this system, be it flag states, coastal states, businesses, or individuals, how can we ensure that they've given their consent to victims to arbitrate disputes that the victims will raise, such that we can have a valid and legitimate arbitral process that ensues? That, for us, I think, is the key challenge. And you'll hear more about that issue from our illustrious second panel later today. Beyond that, it remains for me to thank the core members of our team, starting first and foremost with David Hammond. We're very grateful that he had this idea while taking that shower one morning, and that we were lucky enough to discuss it with him, because it is indeed cutting edge, and we think he was on the right track from the get-go, and that there's a lot to this system that we can make work. Supporting David, I also wanted to thank Elizabeth Marcopoulos, who's been a great asset to us as well as we work through some of these issues, as well as the trustees of Human Rights at Sea, who've given their full support to the project under development. I want to thank again, once more, the absolutely top-notch Shearman and Sterling team working on the project. Banifatemi is leading the team as the partner in charge of the project. She's also the head of our public international law practice, and very personally invested in public international law and human rights issues. And she brings that passion with her fully to this project. We're very lucky to have that. Elise, who's with us as well, and who's going to be moderating the first panel, is highly passionate about sustainability and climate change, and is working on developing that as a niche. And that jives well with what we're doing here in this project as well. So I wanted to thank them for the particular contributions they've been able to provide. Of course, Sandrina and Masha as well, who have been absolutely excellent and passionate about the project, and have worked very hard in taking it forward. So without further ado, and I know we're a little bit ahead of schedule, which is a first for me, I'm going to pass it along to our first panel, and hopefully that gives some more time to our speakers and to the audience to pose questions. I hope everyone enjoys, and thank you again for being with us.